Blissfield, and I am a senior.
My name's Max Freeland. I'm a senior at Blissfield High School.
My name is Reagan Ayers. I'm a junior and I go to LCS.
I'm Anna LaRose. I'm a junior and I go to LCS.
All right. Judges ready? Timekeeper ready? Negative team, are you ready?
Yes.
All right. Every human being deserves the right to live free from abuse. Due to a victim's immigration status, the present system allows abusers to exert power and control over their victims. That's from the National Domestic Violence Hotline. This is why we stand resolved. The United States federal government should substantially reduce its restrictions on legal immigration to the United States. Just to roadmap for you judges, I have 1 harm, 8 inherencies, and 2 solvencies. Harms 1. Spousal abuse is seriously harmful. This is from Lyanna Donovan, Rutgers Law Review, Spring 2014. Women who have been abused by an intimate partner also described experiencing other health issues, including but not limited to recurrent headaches and pain, sleeplessness, asthma, diabetes, and poor psychological health, and were more apt to engage in behaviors that further threatened their health and well-being, such as drug and alcohol abuse. The vast array of ailments, both physical and mental, that female IPV, intimate partner violence victims report experiencing may be related to the fact that IPV perpetrated against women often manifests itself in multiple forms, including rape, physical attacks, and stalking. Inherency 1, the doctrine of coverture gives a husband excessive power over his spouse. This is from Sabrina Balgamwala, Berkeley Journal of Gender, Law and Justice, 2014. Coverture, a mechanism by which a husband may establish power and control over his spouse, has significantly shaped the rights of women in the United States, immigrant and native born, for the past 3 centuries. English jurist William Blackstone defined coverture as a legal construct in which the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband. In this arrangement, a wife is under her husband's cover or protection. Under the doctrine of coverture, a woman's marriage resulted in the extinguishment of her individual legal identity, self-determined interest, and autonomous rights. And just to clarify, that goes for both men and women. Inherency 2. The Violence Against Women Act does not work as intended when there is no protection from deportation. This is from Lyanna Donovan, Rutgers Law Review, Spring 2014. The immigration provisions of VAWA provide a legal way for undocumented victims to break the cycle of violence in which they often find themselves trapped and allow law enforcement to bring perpetrators to justice. Without provisions that ensure confidentiality and allay immigrant IPV victims' fears of deportation, undocumented battered women will remain uniquely susceptible to and disproportionately affected by IPV and the dangers associated with it. Although Congress has taken notable legislative steps towards addressing this particular obstacles afflicting battered immigrant women, in the last 2 decades, the benefits and protections offered to these victims through VAWA can and should continue to be preserved and appropriately expanded. On to Inherency 3. Congress has refused to expand the U-visa cap. Mariela Olivares, professor of law at Howard University School of Law, 2014. Yet, as the U-visa became an important tool to help more battered immigrants, the annual cap of 10,000 U-visas quickly proved to be insufficient to meet the need. Thus, and as discussed below, the increase in the number of U-visas available each year became an important advocacy point for the immigrant activists in the VAWA 2013 reauthorization debate. Inherency 4. Immigration law prevents women from leaving their abusers. This is from Mariela Olivares, professor of law, Howard University School of Law, December 2014. Additionally, an immigrant victim of domestic violence often must contend with the batterer's exploitation of her precarious immigration status. Faced with the batterer's threats to have her deported and or take her children away from her, a battered immigrant may very rationally believe that the reasonable course of action is to succumb to continued abuse. Finally, the cultural constraints and dictations which teach obedience to one's husband and leaving a marriage under any circumstances may operate against a battered immigrant's attempts to escape abusive relationships. Thus, the complexities that an immigrant domestic violence victim may face make her choice whether to stay with or to leave her abuser even more difficult. Inherency 5. The U visa cap contributes to excessive waiting periods. This is from Christina Gasson. Generally, it takes about a year and a half for USCIS to fully process U visa applications these days. However, you should use that estimate as a guideline, not a guarantee. There is a federally mandated limit of 10,000 U visas per fiscal year, and in recent years, all U visas have run out before the end of the fiscal year, which runs from October 1st to September 30th. On to Inherency 6. The Trump administration perpetrates reliance on the spouse holding the main visa. This is from Tal Kopan, CNN, September 30th, 2018. A policy takes effect on Monday, October 1st, that could increase the risk of deportation for undocumented immigrant victims or witnesses of crimes. The agency that considers visa applications will begin to refer immigrants for deportation proceedings in far more cases, including when a person fails to qualify for a visa. The policy would also constrain officers' discretion. On to Inherency 7. Even with VAWA, the waiting period through VAWA is too long to be viable. This is from Sabrina Balgamwala. I'm going to just start reading tags as I see time is running low, and I will come back to this later if I have time. My last inherency, Inherency 8. The threat of deportation undermines the reporting of spousal abuse. Plank 1. The U.S. federal government, U.S. Congress, and U.S. Department of State. Plank 2, mandates. Congress will accept all valid applications of peoples who already have attained residence in the United States. Plank 3, enforcement. The U.S. Department of State will accept all legitimate applicants of U visas in the United States. Plank 4, funding. The salaries of individuals who are employed to oversee the operations necessary for this case. The funding already exists. The reduction of restrictions will be primarily based on mandates. Plank 5, legislative intent assumed. Solvency 1, the U visa cap should be increased. Solvency 2, the U visa allows a path to citizenship. I am going to go back to my Inherency 7 now and read evidence for the rest of the time. Just to remind the judges, my tag for that was, even with VAWA, the waiting period for VAWA is too long to be viable. This is from Sabrina Balgamwala, Berkeley Journal of Gender, Law and Justice, Winter 2014. The Violence Against Women Act does not address the imminent loss of status faced by a dependent spouse in divorce proceedings. An H-4 visa holder will still lose her status in the event that she becomes divorced or her husband changes status without petitioning for her. If that divorce occurs more than 2 years before the principal obtains a green card, she cannot self-petition for an independent path to citizenship under VAWA. And the wait times for permanent residence for H-1B visa holders. All right, I am now ready for cross-examination.
Okay, so pretty much what you're saying is that like with spousal abuse and things, and like if they get divorced, then the wife doesn't have citizenship then unless
They don't have any legal permanent residence at all.
without the husband.
Right,
Okay.
And that goes for both genders, both ways, whoever's the main visa holder.
right. So if the wife is a visa holder, then they,
Okay, thank you.
control
So
the
for
relationship.
solvency, you said that the U visa cap should be increased. How much? What are you thinking?
so our plank 3 says that the U.S. Department of State will accept all legitimate applicants of the U visa who have already obtained residence in the United States.
Okay, so at that point they are legal then. It's not illegal immigrants. It's people that already have status.
Well,
They're just applying for it.
No, so in order to be accepted, you have to apply. So by increasing the cap and accepting the applicants, that gives them a legal status, which they don't already have.
So they don't have legal status when they apply for the visa?
Correct.
And they're in the
Okay,
United
thank you.
States when they apply.
Yes.
But, so can you explain a little bit about, so like if they're married and their spouse has like citizenship or whatever, then they do, but then when do they apply for the visa? Like when?
Okay,
the
so
Inherency 7, if you are married to a visa holder, you are eligible for an H-4 visa. If you divorce the main visa holder, you no longer have right to that H-4 visa.
So you don't have legal status.
Also, could we have a copy of your case and plan before I forget?
Yep.
Okay, so with the H-4 visa, what happens, so
That's not-
if you get a divorce,
that's not-
then it's too late for that. But if you're just being abused, but you're still with the spouse that holds the status, then you could apply
Sorry,
for an
I'm
H-4
sorry.
visa.
Could you repeat that? Sorry.
Yeah, oh, it's fine. So you can apply for the H-4 visa if you're already, like, if you're still.
So
married,
if your
but
spouse
once-
has a visa, you are granted an H-4 visa, which allows you to be legally here while you're with your
But
spouse.
then if you're divorced, then it's too late for that.
If you get divorced, then your H-4 visa no longer has any legal standing.
Okay, thank you. Do you have anything ready? And you only had one harm, correct?
Correct.
All right. And also, okay, so do you have any numbers of like how many people, like, I don't know, any numbers of people who are like, their H-4 visas are like revoked or anything? Like,
So
numbers-wise?
that's the entire point of our inherency 8, is that the threat of deportation undermines the reporting of spousal abuse.
So you don't know,
No, we don't have any numbers on it, but,
because they're afraid to be deported.
right.
Okay, that makes sense. So then with the U visa, then they can't be deported, right? And they're given a path to permanent
Right,
residency?
yes.
So they can apply for permanent residence.
Okay. How many?
Can I just have a minute and a half, please? Can I see this to look at it? Judge ready? Timekeeper ready? Affirmative team ready?
Yep.
Okay, so to roadmap for the judge, I'm going to be hitting on their inherency 1, inherency 2, inherency 4, inherency 7, and running 2 topicalities on the word legal and 2. So to start in their inherency 1, it says that the doctrine of coverture gives a husband excessive power over his spouse. I have evidence that says VAWA provides many forms of protection for immigrant women. From Mariela Olivares, Howard University School of Law, American University Law Review, December 2014 says, particularly relevant to immigrant victims of domestic violence, VAWA 2005 exempted VAWA self-petitioners from 1, penalties imposed for overstaying grants of voluntary departure if the overstay was due to abuse, and 2, numerical limits on motions to reopen relief applications for cancellation of removal or suspension of deportation. Moreover, VAWA 2015 incorporated employment authorization benefits for certain victims of domestic violence, including the spouses of people in the country temporarily for employment purposes. So VAWA provides forms of protection for immigrant women. They can get out of the abuse from their husband. And I also have evidence that says VAWA allows battered immigrant women to continue to live and work in the United States. This is from Rachel Gonzalez Settlage, Wayne State University Law School. Summer 2016. A battered immigrant spouse granted relief under VAWA is permitted to live and work in the United States, apply for lawful permanent residency on her own, and her unmarried children under the age of 21 qualify for derivative status. The importance of removing the abusive U.S. citizen or lawful permanent resident from the visa petition and lawful permanent residency process cannot be understated. Because a battered immigrant spouse is no longer required to stay with her abuser in order to gain or keep lawful status in the United States, she is more likely to seek help. VAWA has literally saved lives. For their inherency 2, they stated that the Violence Against Women Act does not work as intended when there is no protection from deportation. I have evidence that says the U visa quota is irrelevant. Applicants are protected from deportation even if the cap is exceeded. This is from Rachel Gonzalez as well, Wayne State University Law School, summer 2016. Only 10,000 U visas can be issued in a year, and this cap impacts the safety of domestic violence victims. This cap was first reached in 2010, the second year in which the U visa was implemented. Since that time, the number of U visa applicants submitted has far exceeded the 10,000 cap. As of fiscal year 2015, there were 63,762 U visa applicants pending in which no adverse decision has been reached. If USCIS determines that an individual is eligible for a U visa but cannot get one because of the cap, she is placed on a waiting list until a U visa becomes available for her in the future year. So they are protected from deportation even if the U visa quota is exceeded. For their inherency 4, they also stated that immigration law prevents women from leaving their abusers. But I have evidence here that says VAWA removes dependence upon an abusive partner by allowing abused women to self-petition for relief. So they can get away from their abuser. They can leave that abusive relationship. This is from Caitlin O'Neill, Women's Rights Law Reporter, winter 2014. One of the most important provisions with VAWA has the enactment of a self-petitioning process because prior to 1994, immigrants had no legal means to petition individually for residency within the United States. A woman's immigration status was often controlled by her abuser. Research shows abusers actively use their power to control their wives' and children's immigration status and threats of deportations as tools in the abuse process. But VAWA removes the dependence upon an abusive partner and allows the woman to petition for self-relief, getting away from that abusive situation. I also have evidence for their inherency 7 that says the waiting period for the VAWA is too long to be viable. But I have evidence here that states that VAWA works. It has protected 3.4 million people over the last 20 years. Sally Goldfarb, Women's Rights Law Reporter, summer 2017. VAWA changed the legal landscape in the United States. The 1994 statute required states to enforce protection orders issued in other states. It provided funding for a national toll-free domestic violence hotline, which has helped 3.4 million people over the last 20 years. It has increased federal funding for domestic violence shelters and authorized federal grants to increase the effectiveness of police, prosecutors, judges, and victim service agencies. VAWA reformed immigration law to help immigrant victims leave their abusers without being forced to leave the country. So their evidence says that the waiting period for VAWA is too long to be viable, but over the last 20 years, it has helped 3.4 million people and saved the lives of many people in abusive situations. So to move on to my topicalities, I'm going to run a topicality on the word legal. So they stated that when a woman or man is in an abusive relationship, they have I believe an H-1/4 visa, and then when they are divorced, they lose that visa, and so they lose their legal status, and they're illegal. And then they have to apply for a U visa to once again regain that legal status. And so in that waiting period, they're illegal immigrants. And my definition for legal is legal created or permitted by law. This is from Alan Walker Reed, the New International Webster's Comprehensive Dictionary of the English Language, 2004. My standard is framers' intent because the framers intended that when the immigrants were here that they would be legal immigrants, not illegal immigrants, having to then gain their legal status while they are already in the United States, which brings me to my topicality on the word to. My definition of the word to, let me find that. I'm just going to cover it later, but to go over it, most of it, my definition, if I can remember right, is to move from one area to another. And I can read the evidence on it later and my definition and the source. But for now, I'm just going to say that when these people come into the United States and apply for a U visa, they're already there. They haven't immigrated in order to get the visa. They're already there, and then they have to apply for the U visa, which means that they're not immigrating. And my standard would be framers' intent because the framers intended that these immigrants would be moving from one area to another to gain their legal status. Thank you. I'm now open for cross-examination.
Okay, so how does VAWA protect against deportation? Do you know?
So it says that,
Like, what elements of VAWA are there in play to allow for the protection against deportation?
We don't know specifically, but just from our evidence, it just says that even if the cap is reached, they're still protected.
So
from
you
deportation.
don't know what specific elements of VAWA are there to protect people from deportation?
No,
No.
this isn't my case. I haven't researched it that extensively.
Okay,
but we do have evidence that says even if the cap is exceeded, applicants are protected from deportation.
how are they protected from deportation if the cap is exceeded?
We don't know. We haven't researched.
So they
it
don't
that
have a legal status at this point, but they are deported?
I think that's what our evidence says.
Yeah, and they aren't deported.
We don't know specifically. We haven't studied VAWA as intensively as we would if it was our case. We don't.
Could you restate your inherency 7 attack?
VAWA works. It has protected 3.4 million people over the last 20 years.
How do we violate your definition of the word legal?
Because when you're putting in the plan to allow the, I believe you want to eliminate,
Do you want me to try to?
yeah.
Okay. So from what we gather from Cross-Ex, you're saying that like when they're married to someone that has legal status, they have the H-1B or H-1-4 visa, right?
H4, yeah.
H-4, whatever. That visa, that specific visa. So then once they get divorced and that is lost, at that point they're illegal and then they go to apply for another visa. Like,
Right, so
they can
would allowing people to legalize be reducing restrictions on legal immigration?
stay. Can you rephrase the question?
So allowing people to legalize,
Uh-huh.
making it easier to legalize, isn't that reducing restrictions on legal immigration?
Yeah, but we're just saying.
Yes?
Yes.
Okay,
That's exactly what we're doing. Okay.
so we are topical then.
I'm not going to admit to that.
Okay.
So no.
And you did not provide a definition of the word "to."
No,
No,
my
I'll
partner
get
will
to that.
provide that.
Was all of your inherency evidence about VAWA?
No, it also talks about the U visa.
Okay, so VAWA and the U visa, which our plan is to give out more U visas, right?
Yes.
Okay.
Any questions?
All right, yeah, no, I don't have anything else. Could I get a minute 30, please?
I'm grabbing my definition. Yeah. Okay, so here's evidence for this if you want to go over that, you have time. Yeah.
I wanted to see the evidence.
Is that okay?
Has not been reauthorized for 2019.
Okay.
Which one?
All right, Judge, ready? Timekeeper, are you ready? Negative team, are you ready?
Yes.
All right, judges, I'm just going to roadmap for you. I'm going to refute the inherency 1, 2, 4, and 7 attack, as well as the topicality on the word legal and the topicality on the word to. I'm going to start off with those topicalities, starting with legal. They said that by reducing, by making it easier for people to legalize, they admitted that it would be reducing restrictions on legal immigration, which is the resolve that we are operating under. Therefore, we are topical. They said that they wouldn't admit that we were topical, but they were just doing that to just say that to stick to their argument rather than actually looking at the facts and looking at what we are actually doing and the grammatical context of where legal is in the resolution and how it is actually applied to our case. I actually have a definition that says legalization refers to changing the status of those present in the country. I can read that for you right now. This is from Judith Resnick, professor of law at Yale University, Immigration, Emigration, and Migration. Legalization is typically used in reference to changing the status of those present in the country, but its deeper purpose would be to override the idea that border crossing without permission is illicit. Legal activities can, of course, be subjected to regulation, including penalties such as civil fines and restitution for noncompliance rather than governed by regimes reliant on deportation and incarceration. So that is exactly what our case is doing. We're taking people who did have legal status, who left the person who gave them legal status, therefore not having legal status, but we are making it easier to apply and easier to receive a U visa, which gives people legal status and legal standing in the United States. So if their abuser is deported because they have been committing a crime, spousal abuse, they are not deported along with them. In many instances, these people migrate from the same area. These people are married, and then once they come into the country, the abuse continues or the abuse even starts, and then they can't leave their abuser because their abuser is their only way that they have a legal standing in the United States. So if they were to go out and say, this person is abusing me, they would be deported because they can't say that without the other person present, which the inherency one argument that, hold on just a second, the doctrine of coverture gives a husband excessive power over his spouse. They said that VAWA provides many forms of protection and allows people to apply for this path to citizenship and allows people to work in the United States. What they are describing is a U visa. I have a piece of evidence here from American University, Washington College of Law, that it says the Violence Against Women Act of 2000 created the U visa for immigrant victims of qualifying criminal activities. This visa offers temporary lawful immigration status to victims of certain criminal activities if the victim has suffered substantial physical or mental abuse as a result of the criminal activity. So the U visa is the protection that these people are offering, that VAWA is offering. The U visa is what lets people stay in the country as a non-immigrant, and the U visa is what allows for these people to petition to be in the U.S. as an immigrant permanently and to naturalize. So every argument that says that VAWA protects adequately is really null and void because VAWA is what created the U visa in the first place. Not to mention that VAWA as an act has to be reinstated every year because of the fiscal budget. And the fiscal budget report from this year, October 1st, VAWA was actually extended to December 7th. A decision has not been made whether or not to include VAWA in 2019, and there have been multiple debates throughout the years in 2005, 2013, and again this year, where they are debating whether or not VAWA is necessary and whether VAWA needs to be reinstated. So by removing the cap on the U visa, you are ensuring that people have access to the protection that VAWA created in the first place without actually relying on VAWA to create any more protections that may or may not arise in the next coming year. So without VAWA, the U visa still stands as a visa, but VAWA can't do anything to protect these people, which they didn't provide any actual specific protections that VAWA can provide, but if VAWA is disbanded, then the better alternative, and the better alternative altogether, is the U visa. So by removing this cap, we are solving for our harms, and that really refutes every attack on our inherency that the affirmative team put out. They said that VAWA provides many forms of protection against our inherency one, but again, VAWA provides the U visa as protection. They said that VAWA allows a path to legal residency, but VAWA was just the creator of the U visa, which allows for a path to legal residency. They said that women don't get deported even if the cap is reached. Whether or not that's true, they still don't have a legal status if they leave their husband. So if an undocumented immigrant is out and about in the world and for any reason is stopped by international customs enforcement or any kind of law enforcement, and they ask for some kind of proof of residency or proof of proof of legal residency and an undocumented immigrant says, well, I'm waiting for a visa, they are still undocumented and would get deported. So that isn't any kind of insurance. Whether or not an applicant applies for a visa and they say, well, this person can't get a visa yet, so they are undocumented, we're not going to deport them because of that reason, but they can be deported for any number of other reasons because of their undocumented status. So removing the cap on the U visa and allowing people to obtain U visas would solve for that. Moving on to Inherency 7, it says that VAWA has protected 3.4 million. They, again, did not provide any actual protections. We have an actual protection that is the U visa. So the U visa may have been what protected 3.4 million people in the last 4 years. So really, that argument is unsubstantiated because VAWA's protections, the U visa, as I have previously stated, are really what the negative team is relying on, and that is what the affirmative case is dealing with anyway. We are expanding VAWA's protections and allowing VAWA's protections to stand on their own without VAWA in case VAWA is not reapplied to 2019. Moving on to the to topicality. They did not provide any definition of the word to, but in order to clarify what the word to means, I'll be looking at the resolve yet again. The resolve says, resolve the United States federal government should substantially reduce its restrictions on legal immigration to the United States. So if we take out the phrase on legal immigration, the resolve would then state, resolve the United States federal government should substantially reduce its restrictions on the United States. So the government should reduce the government's restrictions on the U.S., so to the U.S. So to is meaning a possessive prepositional phrase of the United States. So the United States has these restrictions placed on it by the government, and that restriction would be that people are not allowed to legally come into the United States. So the phrase to the United States is a prepositional phrase. Most people assume that that applies to immigration, but if it were applied to immigration, that would be redundant. So even if there's an argument that it's a compound prepositional phrase, that would still be mute because immigration already implies that people are coming to a foreign country. So it would most reasonably be applied to the United States, where the restrictions, could I finish my sentence, please, are the governments that are being placed on the United States as a geographical area. Thank you. I'm now available for cross-examination.
Okay, so to start, you talked about how the U visa was created by VAWA, but now you want to make sure it can stand without VAWA. But so the U visa could exist without VAWA.
Right.
So if it isn't renewed in 2019, like the fiscal, whatever, it would still stand.
The U visa would.
Yeah.
Yes.
So, but why do you think that it would ever not be renewed if it saved so many people, or you think that?
Well, there have been multiple debates throughout the years, and I don't think it got renewed in 2015. I don't have any evidence to support that, but since there's a debate, there's always a chance that something might not get reinstated.
There's been years it's been highly
Okay,
contested.
also, okay, so the thing about the prepositional phrase, so you think that to the United States modifies,
Restrictions, not immigration.
so
restrictions
to the United States.
Placed on it by the government,
What
yes.
does that, restrictions to the United States? How,
So,
what, in your own words, what do you think that means? Just restrictions to the United States? I'm not quite sure.
so what kind of restrictions? Restrictions on legal immigration. So legal immigration, you're prohibiting people to legalize in America. You're restricting America's ability to accept legal immigrants. Does that make sense?
So if what you're saying is right, that you're having restrictions on immigration, then wouldn't it make more sense to say restrictions on legal immigration?
I don't think that restrictions can stand alone because it doesn't specify what restrictions are.
Well, that's what,
to the
on
immigration,
legal
to the United
immigration.
States.
Restrictions on immigration to the United States.
I think
Restrictions to the United States. What kind
of
of restrictions? Restrictions on legal immigration.
Okay.
Okay, also on the top, Kelly, when you said, I don't know, something about we would not admit that it isn't topical, could you just go over what you said about our topicality, like your attack on our topicality?
So you admitted that by making it easier for people to legalize, we would be reducing restrictions on legal immigration. You admitted that during cross-examination.
So.
And then I said, so are we topical? And you said, I'm not going to admit that.
So when they lose their H4, is that what you said?
Yes.
H4 visa, they are legal, right? they have a legal status.
At
When they
point.
have
At
the
that point, they are
the
illegal.
H4?
No, when they
But
lose
when
it.
they lose the
When they
H4,
lose it.
at
They're
that
in the United
point, they
States
are
as illegal
correct?
immigrants.
Correct.
Okay.
So allowing them
So-
the
and then
opportunity
the
to
two-
legalize.
So then your plan provides a way for them to become legal while they're illegal in the United States.
Correct.
And
Okay.
then for the two topicality, you're saying that why, so we're saying that they have to like move some from one place to another, so that has to do with your grammar lesson about the restrictions.
Right. So I'm saying that to does not mean a movement. I'm saying that to is the possessive preposition of restrictions.
All right. Can I have a minute and a half, please?
Yeah, did you, oh, actually, never mind, that makes sense. Okay, so they said, no, about the, there's no catch all of it, but I got most of it. I don't think I got one for yours. So they're saying that. Wait, which one's for the two? Which one's for inherency two? This one? It's on the back. I think that's a one. Okay, can you just like have it like so I can look at it? So I think I just took it. Right? Yeah. Just for context. Yeah. It's like context and grammar sometimes, right? Yeah, I understand. Well, should for substantial should it be or like precision if they're bound or something, I don't know, right one. Okay. Okay. Judge ready? Judges ready? Timekeeper ready? Affirmative team ready?
Yep.
Okay, just the roadmap for the judge, I'm going to go over again our attacks on their inherent states 1, 2, 4, and 7. I'm also going to go over our topicalities on the words to, legal, and I'm also going to add a topicality on the word substantial. So just to start on the topicality with the word substantial, first of all, our definition of substantial is to a great extent. So I would just like to point out that in their inherency 8, they said the threat of deportation undermines reporting of spousal abuse. And in cross-ex, we asked them for numbers, and they said, well, you know, it is hard to have exact numbers because they don't know how many because people are afraid of being deported, so obviously you're not going to report every spousal abuse. So we'd just like to point out that our standard is limits, and we just aren't really sure how, if they have no numbers, how is it substantial? There's no standard of if the number of people that are being abused is substantial or not. There are literally no numbers, exact numbers that we can be sure of. Also, topicality is a voting issue. So to go back to our topicality on the word to, so they said that it modifies restrictions to the United, I'm sorry, I'm getting mixed up. So they're saying that it modifies the word restrictions, like how they're coming into the U.S. But we're saying that it modifies like immigration to the U.S. is what we're saying that it modifies. So then that would go back with our definition of to, which is with motion, a direction towards something. So what we're trying to say is that it's not modifying restrictions. Just saying restrictions to the U.S., it doesn't tell us anything. It can just be any restrictions. What we're saying is that restrictions and then of like immigration to the United States, the to the United States modifies modifies immigration and how they're immigrating to the U.S., not restrictions to the U.S. because restrictions to the U.S. makes no sense. It doesn't tell anything about what restrictions, and they're saying that that's where the immigration comes in. But if you think about it, to the United States modifies how they're immigrating, not what restrictions there are. And then again on our topicality on legal, so our definition or our standard is framers' intent and limits, because so once the people are divorced, they lose the H-4 visa, and at that point, they are illegal. In the U.S., they're still illegal, and then they go to apply for the visa. But with the framers' intent, we're talking about people that are just immigrating to the U.S., people that are going from somewhere, coming into the U.S. illegally, or legally, not illegally. So once they lose that visa, the H-4 visa, and they have to apply to a new one, then at that point, they are illegal. That is not topical. At the point that they apply for this new U visa that they want to erase the cap on, they are illegal in that exact point. And again, to go over all of our attacks on their inherencies. So for inherency 1, we have evidence that says that VAWA is doing good things. It allows battered women to continue to live and work in the United States. So this shows that there are, like, VAWA is helping people that even though they do have, either whether it's the husband or the wife, whoever has like the legal status, that they are still helping them and they can still go and live and work in the United States. And then for our attack on their inherency 2, so the U visa quota is irrelevant. They're saying that they want the U visa quota to be able to stand alone, like without VAWA. So even though VAWA created the U visa quota, they're saying that even, you know, like if it doesn't get like renewed in like fiscal year 2019, that the U visa quota will still be there to help people. But we have evidence that says the U visa quota is irrelevant because applicants are protected from deportation even if the cap is exceeded. And they said, although they did point out that we don't have we don't know exactly how they are protected, we do have evidence that states that from a credible source. And although we haven't researched this topic as extensively as they have, obviously, because it's their plan. It's not their plan, or it's not our plan. We're just pointing out that we have evidence that states that that isn't a problem, that even if the cap is exceeded, then they still won't have the fear of deportation. For their inherency 4, it says, immigration law prevents women from leaving their abusers, but VAWA has provided, and it says, many forms of protection for immigrant women, not just one form, which would be just the U visa. It says many forms, and again, we don't have specifics, but it says, like, there are many, not just the U visa, so not just getting rid of VAWA completely and just standing alone on the U visa, because VAWA provides many different forms of protection for these women, as opposed to just one, which is the U visa. So it's better than just completely eradicating VAWA and just keeping the U visa, as opposed to keeping VAWA, which has like many ways to help the women. And then for inherency 7, which says the waiting period of VAWA is too long to be viable, but obviously we can see from this evidence that it is viable because it says that it has protected 3.4 million people in just the last 20 years. So I would say that that is viable because if you look at the numbers, how many people have helped by VAWA, not only by the U visa. It doesn't say how many people have been helped just by the U visa. This is VAWA as a program, so they're trying to even, I mean, it does include the U visa, but this is VAWA as a program, how many people they have helped just in the last 20 years, so I would say that that is viable. And again, if, like they said, VAWA isn't renewed in 2019, then there's no way to ensure that like there would be that many people, because there would be that many people that would be saved just by the U visa as opposed to like VAWA as a whole. And then just to go over our new topicality on substantial, again, we're just saying that since they have no limits of how many people are abused each year because they aren't deported for fear of deportation, then we can't guarantee that it's substantial because there is no standard or limits for it. Thank you, I'm now ready for cross-ex.
So you said that there was no way to ensure that people would be protected without VAWA if VAWA wasn't renewed for 2019?
We're saying that like our evidence says that like 3.4 million people have been helped like by VAWA over the last 20 years, and it's not just
over the last 20 years.
Yeah.
Okay, so if we let people have U visa status and we gave them a legal status and we gave them those protections, wouldn't that be a viable option to ensure that they have the protections that were guaranteed to them?
It would be, but we're saying that VAWA is also doing that, which is what our evidence states, because your plan is saying that like VAWA isn't doing a good enough job.
Right, because there is no protection from deportation.
But we have evidence that says there is.
Exclusively through the U visa.
It doesn't
It doesn't
say that.
mention the U visa.
It just says that VAWA protects. from deportation.
Okay.
Even if the cap is reached.
Okay. So right now you have the inherency 1, 2, 4, 7, the 2 topicality, and the substantial topicality. Is that correct?
Yes.
Okay, and that's it?
Mm-hmm.
All right. And your refutation against the VAWA is that it still provides protection even if the cap is reached.
Yes.
From
All right.
deportation specifically.
And the 2, you just said it didn't make sense to modify restrictions, not,
We're saying that to the United States modifies how they're immigrating, not
Or-
restrictions.
Yeah, it
to the
clarifies where
United
they're
States.
immigrating, which is to the United States. It doesn't clarify
Can
restrictions.
you define immigration for me?
You mean like in my own words, or you want me to dig
Yeah,
out
in your own
topicality?
words.
We say like moving from one place where you're not native into another place.
Okay,
So like where they're already here,
so if the U.S. federal government is dealing with immigration, doesn't that mean that the immigration is implied to be coming to the U.S.?
yes.
Yes. So doesn't that make to the United States redundant?
No,
It's-
it
No,
clarifies.
it clarifies where this
grammatical
immigration
context.
is.
Well, since it was already clear to you that the U.S. federal government dealing with immigration would mean that the immigrants are coming to the United States,
It's saying that the U.S. federal government is dealing with immigration to the United States.
so
Just for
So as opposed to
clarification and
immigration
context.
to Pakistan?
Sorry,
Sure.
what was your question?
So you say that it needs clarification. Why does it need
We're not
clarification?
saying it needs clarification.
saying
we're
it's
saying
there.
it is clarification.
So you're saying it's redundant. It
No.
doesn't
No.
need it.
We're saying the
in
United
grammatical
States federal
context.
government is dealing with immigration to the United States.
Right, so why does it need to the United States?
Because it's
if-
clarifying where the immigration is going on. It's
So like
in the
as
United
opposed to
States.
like immigration to Canada?
Yes.
Can I have a minute and a half, please? Got it. Can you write it? I'm gonna put Can I, okay, oops, sorry. Did you say the standard for, number 2? What is this? 2. So 2, and you said from some time. Yeah, and you should say.
so these 2.
Where's that? Okay, so, for substantial, it's because, can I have 30 more seconds, please?
Because of their inherency, because this is the deportation under laws requires and spousal abuses, and they say themselves like it's hard, but they don't have an exact number because the people who say they deported, they don't like support, so it's hard to tell how many are
So,
for what, how many are abused, or how many are abused, how many are abused.
Okay. Judge ready? Timekeeper ready? Affirmative team ready?
Yep.
So to roadmap for you judges, I'm just going to be going back over our 3 topicalities and our attacks on inherency 1, 2, 4, and 7. So to go back on to the topicality on 2, the affirmative team said that 2 modifies restrictions, so to the United States. But we believe, based on grammatical context and framers' intent that they mean that it modifies immigration, because it's clarifying that it's the United States federal government is dealing with immigration not just in any other country or anywhere else around the world, but to the United States. They're dealing with immigration to the United States, not restrictions that have to do with to the United States. And then to go back over our topicality on substantial, in their inherency 8, they said, the threat of deportation undermines reporting of spousal abuse, which goes with that because to have no numbers to go off of who is abused, because the people who are in these abusive situations don't report it because they're afraid of being deported. And once again, our definition of substantial is to a great extent, and this is from the Oxford Dictionary and Thesaurus, 2017. And then to go back on my definition of to, once again, it's used for expressing direction or motion, and this is from the Random House Dictionary of the English Language, unabridged, 1987. And then to go on my topicality on legal, so the affirmative team admitted that while the person in the abusive situation loses their H-4 visa because their spouse has divorced them, they are legal or illegal, and they're in the United States as an illegal immigrant, and therefore they can't be legal, which is in the resolution saying that they have to deal with legal immigration because they are illegal. And once again, our definition for legal is created or permitted by law, and this is from the Webster's Comprehensive Dictionary of the English Language, 2004. And then I'll go back over and cover my attacks on inherency 1, 2, 4, and 7. So for their inherency 1, once again, they stated that that the Violence Against Women Act does not work as intended when there is no protection from deportation, but we have evidence that says VAWA allows battered immigrant women to continue to live and work in the United States, which is from Rachel Gonzalez, Wayne University Law School, and this is from 2016. So it says that under VAWA, they are permitted to live and work in the United States, apply for a lawful permanent residency on her own, and her unmarried children under the age of 21 qualify for derivative status. And then for that same, for their inherency 1, I have evidence that, once again, that says VAWA provides many forms, so more than one form of protection for immigrant women, which is meaning not just the U visa. This is from Mariela Oliveras, University Law Review, December 2014. So it gives them, so it says VAWA 2005 exempted VAWA self-petitioners from penalties imposed for overstaying grants of voluntary departure if the overstay was due to abuse, and 2, numerical limits on motions to reopen relief applications for cancellation or removal or suspension of deportation. And then to go back over my attack on inherency 2, they said that the Violence Against Women Act does not work as intended when there is no protection from deportation, but we have evidence that says the U visa quote is irrelevant because applicants are protected from deportation even if the U visa cap is exceeded. This is once again from Rachel Gonzalez, Rutgers Law Review. Can I finish my sentence? Oh, did you say 30 seconds or? Oh, okay. That even when the cap is exceeded, that they are protected from deportation. Thank you. Please vote negative.
I'll take a minute.
Sorry, I didn't even want you to flow, but it's basically everything you said. So keep this in mind that it clarifies when people are where people are. Yeah.
And these are the programs that they're on.
So, inherency 2, 4, 7. T on.
All right.
Legal 2 and substantial.
Judges ready? Timekeeper, are you ready? Negative team, are you ready?
Yes.
All right, judges, just to roadmap for you, I will be going over all of the topicalities in play and then onto the inherency attacks. I will start with the legal topicality. We are reducing restrictions for immigrants to come to, we are making it easier for more immigrants to become legal. Therefore, we are reducing restrictions on legal immigration to the United States, just as the result states. Therefore, we are topical. They admitted it earlier in the debate. We've had logical reasoning from my partner, and all of which points to the fact that we are fitting the resolve. We are reducing restrictions on legal immigration to the United States, even if they are illegal at the time. They are becoming legal. Therefore, we are reducing restrictions on legal immigration. Onto the two topicality. The affirmative team stated that 2 was a direction towards. That would be a redundant statement because the United States can't reduce restrictions on any other type of immigration. It can only reduce restrictions on immigration to itself. M means into, or, M meaning immigration to itself. So it can only control that type of immigration. Therefore, the phrase to the United States would be redundant, and the framers would not put a redundant phrase into the resolved, operating under the negative team's definition. Under the affirmative team's definition, however, of it being a possessive prepositional phrase modifying restrictions, it does make sense, and it is not redundant. So therefore, the framers obviously intended it to be the affirmative team's definition. Onto substantial. We disagree with the definition that the negative team gave. Their definition, to remind you judges, was to a great extent. Our definition is socially important. This is from Christine Lindbergh, Oxford College Dictionary. Substantial, important in material or social terms. Obviously, protecting a person from abuse is obviously socially important, as it is that person's health physically and mentally. Onto the inherency attacks. So I have a piece of evidence from Inherency 8 that I did not read in my 1AC. This is from Coral Engelbrecht, CNN, June 3rd, 2018. So keep in mind, on June 3rd of 2018, VAWA was in place and the U visa cap was filled at the time. So this is a story about how a woman feared for her life because of a boyfriend who beat her. VAWA is in place right now, but the U visa cap is filled, and she has no escape route at this time. Why didn't she just go to VAWA? Because VAWA doesn't offer valid enough protections, but the U visa does. Say if this was in January, she could have applied before the cap was met, and she could have escaped this abuse. But since it was in June, when the cap was filled, she could not do this, even with VAWA in place. I'm going to read that evidence for now. For years, she slept with a gun under a pillow, living in fear of a boyfriend who beat her, controlled her life, and threatened to kill her and her children. Demencia, who came to this country illegally from Mexico, became a part of the booming immigrant... thank you, judges. Please vote affirmative.
How much time do we have left? Can you run it, please? judges ready? Timekeeper ready? Affirmative team ready?
Yep.
Yeah.
Okay, just a roadmap for you judges. I'm going to go over all of our topicalities and also all of our attacks on their inherencies. So just to start with the two topicality, I would just really like to stress this. So our definition is in the motion of or the direction towards something. And they said that it modifies, again, restrictions. But if the United States were not, if it was admitted from the resolve, then people could argue that, you could argue cases where people are immigrating out of the U.S., not specifically into the U.S., because the resolve says the U.S. federal government should substantially reduce restrictions on legal immigration. And if you take out to the United States, then it could be legal immigration out of the United States, not specifically dealing with legal immigrants coming into the U.S. Also, they can say it is redundant. They can say it's redundant, but it doesn't make any sense if you leave it out just to have restrictions to the U.S. It needs context, it needs something, and that is immigration, because to the U.S. modifies immigration and what kind of immigration they're talking about, because like we said, they could be talking about immigration out of the U.S. to somewhere else. So to our topicality on, substantial, our definition was to a great extent. Their definition was socially important, but our standard is that you have to have limits, because you can't debate you can't put a limit on what is socially important. It's literally impossible because it's subjective. There has to be some limit, there has to be something there that you can say, like, this is, like, there has to be limits. You can't debate social importance, because that is different to everyone. So our standard is limits, because it has to be limited some way, or we wouldn't be able to debate it, because it would be endless. There literally would be nothing that wouldn't apply. And then back to our topicality on the word legal, they literally said in their last speech, even if they are illegal at the time, talking about when they applied for the visa, even if they are illegal at the time, they're still making it easier and reducing restrictions to immigrate to the U.S. But they literally said that even if the people are illegal while they are applying for the visa, they are still topical, but that doesn't make any sense. It's talking about legal immigration only. If they are in the U.S. illegally, then that is untopical. So they literally admitted to being illegal while the people apply for the visa. Also, they said that we admitted that they were topical at some point, but we never admitted that. So just to hit again on all of their inherencies, 1, 2, 4, and 7. To start with their inherency 1, they said the doctrine gives the husband excessive power over his spouse, but we have read evidence over and over that shows how VAWA is helping immigrant women who have been abused to continue to work and live in the United States even without their spouse. Also for inherency 2, we have read evidence that says the U visa quota is irrelevant because applicants are protected from deportation even if the cap is exceeded. And they started to give an example of a woman that came here and was abused by her boyfriend, slept with a gun, all that thing. And although they were not allowed to finish, their exact words as their time ran out was something about she came here illegally. So they were trying to read evidence, I think, against how even though the cap was exceeded, that she was still afraid of being deported, but she came here illegally. So at that point, I think that what they're going, I mean, they didn't finish the story, but what I can gather from that is that she was illegal. She came here illegally. She wasn't legal immigration. And then for inherency 4, they said immigration law prevents women from leaving their abusers. But again, we've read over and over that VAWA provides many forms of protection for immigrant women. They aren't trapped there because VAWA is helping them and will continue to help them, even though the U visa is part of their program. There are other parts of their program that help as well. And then for inherency 7, the waiting period for VAWA is too long to be viable. But again, VAWA is helping these women to get out of these abusive situations, and it is viable because so many of them have been helped and will continue to be helped as long as it stays in place. Thank you. Please vote negative.
How much time do I have left? Just run it, and I will stand up when I'm ready.
All right, judges ready? Timekeeper ready? Negative team, are you ready?
Yes.
All right, judges, just to go over everything, I'm going to hit on the legal topicality, the substantially topicality, the two topicality, and the attacks on all of our inherencies. I'm going to start off with the legal topicality. So legal in this sense means permitted by law. We agree with their definition, we agree with their standards, we agree that topicality is a voting issue. But the entire point of the resolve is to reduce restrictions on legal immigration. So by allowing people to legalize, which they said, by making it easier for people to legalize, we are reducing restrictions on legal immigration, which is part of the resolve. They said that we were making that easier. They said that we were reducing restrictions on legal immigration. I then asked if we were topical, and they said that we aren't going to admit to that. So they are just trying not to admit to something that is true because they admitted that it was true, but just in order to stick to their argument. So that argument should be brought to the affirmative side because of logic, because of their admission that it was adhering to part of the resolution, therefore to the whole of the resolution, and because of their decision to ignore the fact that we are in fact topical. Moving on to the substantially topicality, we said that substantially means socially important, and they said that this was an irrelevant argument, and it does not create, or their standard was limits because it does not limit the topic. But we are sticking to our guns on that. We're saying that substantially means socially important, and we're using the standards of bright line and ethics. Either something is socially important or it isn't. So there can be arguments made for other things, but beating someone's spouse is definitely socially important and is morally wrong. So ethically, that argument should be brought to the affirmative side based on that definition that it is socially important. As for 2, okay, I'd like to hit on this. 2, immigration to the United States, immigration implies that people are coming in. Immigration out of the United States does not exist. That is referred to as emigration. And the United States cannot place restrictions on any other country on their immigration policies. So immigration policies for the United States are what are being restricted. So that is what 2 means, to the United States, not to any other country. So we can place restrictions on other countries by saying you're only allowed to send people over here, but that isn't immigration, that's emigration. So the immigration to the United States, yes, immigration means coming towards something and coming into the United States, but 2 is referring to the restrictions belonging to the United States, not the direction of the actual immigrants. Moving on to our inherency evidence. So their argument here is that VAWA offers all these protections. They don't have any evidence as to what those protections are, but I have evidence right here that says the programs and services of the VAWA, or the Violence Against Women Act. Federal Rape Shield Law, community violence prevention programs, protections for victims who are evicted from their homes because of events related to domestic violence or stalking, funding for victim assistance programs like rape crisis centers and hotlines, programs to meet the needs of immigrant women and women of different races or ethnicities, programs and services for victims with disabilities, and legal aid for survivors of domestic violence. Persons who are covered under VAWA immigration provisions need to petition, and that is what our evidence of our inherency 7 is saying, that the petition time in order to get these provisions, these legal provisions from VAWA, is too long to be viable. This evidence says right here, if that divorce occurs more than 2 years before the principal obtains a green card, she cannot self-petition for an independent path to citizenship under VAWA. So the U visa adequately solves, and it solves better than VAWA because it provides this path to citizenship without any other requirements. So that really knocks out the inherency 1, inherency 2, inherency 4, and inherency 7 arguments because we have provided the exact protection that VAWA created in order to protect women, and the legal substantially and 2 topicality, I believe that I have adequately logically refuted and given standards to say that the affirmative team is actually affirming the resolution, and that is why topicality is a voting issue. Thank you, judges. Please vote affirmative.
No handshake?
I'm sick.
Too late. You wanted it.
It's okay, I'm sick too.
Okay, that's fair.
Oh, well,
Sorry. Just wash your hand.
no.
Honestly, like, you know, like, how the... Hey, you do you. Wash your hand.
Absolutely.
Honestly, like, you know how there's those debates where, like, you go, like, you get done and you're, like, really mad?
Yeah.
Like, I'm not mad.
No.
Yeah, me neither. I don't care.
I'm ready to sleep.
Against you.
Wow.
Wait, hold on. I hope that makes it on the video.
Yeah.
It's so gross.
Sorry.
Reagan,
Oh,
okay.
this is something reversed.
Yeah.
Right? Also, like, one case that I went up against today was like we're providing food, cash, and housing to immigrants. I forget which school had it. It was Hudson. Okay. And I was like, do you know how many immigrants you're providing food, cash, and housing to? And they were like, no. So like, if they had given me a number and I had the number of, or the amount of cash that was given out to everybody, that I could have funded this.
Yeah, that makes sense. When do they decide who wins?
I don't know.
Yeah. They have to Max. They have to Well, it's not gonna be a while. It's gonna be a day. Max. When do they decide who wins? When do they do that? Right now.
Well,
Varsity.
yeah, they're judging
They
right
just have to
now.
like think about
And then,
Oh, they have to think
so
about
we're
it.
probably gonna go down there, hang out, talk to people.
I'm fine with that.
Yeah, me too. Do you want to take these back? Let's just dump them back when we get to the school. Or actually, let's just do it in the trash can.
I'm so glad that I brought my laptop today.
This petition was good. I didn't realize what it was.
you want in front of the table or behind the table?
Let's just get rid of the table.
Let's stand on the table.
Do you want?
On the table. On the table.
Let's do it on the table.
Well, wait. I don't want to be. Why don't you?
I would just like to thank my Lord that Jesus.
Bye.